Here go objection part two. Don't forget when you object, you're objecting to the judge, not the jury. As I said before, hold on, let me start over. First of all, I am not a certified attorney. I have never went to school for attorney. I did attempt to go to school paralegal, which is just a glorified attendant for the law, who is get the statutes down, send it to the attorney who can also do further research. Well, enough said of that. Besides them, just pricks here hacking my stuff and hacking my stuff, hacking my stuff, hacking my stuff. But anyway, objection. Um, you're objecting to the judge, not the jury. The judge will sustain or overrule. This is what I'm saying all about terminologies. When a judge objects to your order, overrule usually mean that your objection is denied. Sustain, like I said before, mean the objection agree. The judge agree with your objection. Remember correctly, let's the other way around. Now, when you object, you need to be timely. If you say it too far out there, the judge will say something like, I don't know, 2 seconds too late or something. I don't know. And stand up, always stand up. Most states have their own laws. I have not looked up North Dakota laws yet fully. I did look up a little bit with my lawsuits, and it does emphasis on going for the courts, most of them. I don't need to stand up, but state my ground. If I'm objecting something like objection is what I'm objecting while standing up. It calls for what's my ground after that calls for. Objection calls for hearsay, or objection calls for irrelevant. Hearsay, irrelevant, vague, and ambiguous are the ground sides. And then this is directly towards the judge, not the juror. You don't want to talk too much unless the judge wants you to explain the objection itself, which I find it kind of odd because you're a judge, you've been doing this job for 400 years, you should know why they're doing it. Objection here say, explain a, but whatever. And ask for the sidebar. Sidebar is well, from when I do my own research on it, sidebar is when two attorneys or two people go directly to the judge and talk, like stuff like that. Basically, you just walk to the judge. Once you get the judge approval, of course, do so. And like different states have their own laws and terminology. Hey, welcome to the United States of America. Whatever, 50 billion terminology for one law. Whatever. Like one of my recent lawsuits saying like they want to do a magistrate judge, meaning I sit down with them and their attorney and we talk to the magistrate judge and these douchebags try to power roll. I'm like, yeah, I see y'all in court. But no, but we will make you lose. I'm like, yeah, I see you in court. We will that whatever you just said sound totally illegal so far, but I'll see you in court anyway. We'll make you go homeless. I'm already been homeless before. I ain't intimidated. You know. Anyway, magistrate judge is a more like a judge before the judge, like someone who you negotiate first. Yeah, cause like there are certain situations where you need an attorney, and situation you don't. The situation you need an attorney is a bunch of bullcrap. Like I can't serve the subpoena myself. In the state of Alaska, I can serve the subpoena myself, but in the state of North Dakota, I cannot serve the subpoena myself, which is quite odd. Because it's a federal law to not serve the subpoena. It's different from a state like California and freaking Arizona and that stuff as well. Like you don't have federally, you can't have a that still permit, but state-wise, you can have a that still permit. Don't mind me, guys. And the only reason why you can't have it federally because it weakens the economy on petroleum, where we need to save petroleum because it's dangerous to the earth. L, but off subject. There's also these are the type of ejection, not the form of ejection. The type of ejection goes with the ground, while the form of ejection, which is an argument ejection, a leading objection, open-ended objection and stuff like that. Those are the form of objection. Now, the type of objection which also holds your ground are hearsay calls for hearsay, where it says a bullcrap lie. Objection calls for inadmissible evidence. Objection calls for vague and ambiguous, or objection calls for improper characterization, or objection calls for as an angle, or objection calls for speculations, which means I'm trying to mind read what they ask. Objection call for leading the witness, which is a part of the form. And basically, just go back to the form of objection, which I've made too far into it. The form of objection is does argumented, open-ended, leading, and there's a few other ones which I have not got that far in. A argumentative form of objection is when your opposing opponent trying to badger the witness, intimidate the witness, scare the witness, just ask random questions like how's your day going, what you do here, blah blah blah, blah blah blah. Objections call for call for argumenting the witness or badgering the witness or call for intimidate the witness and stuff. Those are argumentative objections, which is bullcrap. You know, sometimes they can be used in your favor. Sometimes it can't be used in favor. If you're going by trial by jury, which means you trial by other people, which I'm going to get to later on, it means that the jury is unheard of. In a day, it's pretty hard to say who decides who in the court. Because if you go to trial by jury, the jury decides your fate or who win or lose the court case, and sometimes that can be overruled by the judge under certain circumstances, and then it can go either or. You can kick out the jury if you want, but I recognize him. He's not freaking whatever he should leave out or she should leave out, but that's a whole other video. Anyway, take this another form. Attorney one say, why did you pull off your clothes to get naked for him? Attorney two say, objection, speculation of the witness. No, hold on, say this. Attorney one asked the witness, um, why did the officer get out act nervous towards you as they got the car? Attorney two, objection, calls for speculations. It's not my job to read them. Not my job as the witness or myself to read the mind of a police officer. Your duty as a police officer to be well trained to handle a situation comes in smoothly, not just point your gun and oop, actually shot was nervous. Which is called for speculation, because speculation is still something that you have to read their mind, their attention, like basically a mind reader. Here goes another one. Attorney one asks the witness, or you, for example, why did a person look at you and just start merely talking trash? Attorney two, objection, call for speculation and ambiguous and vague evidence or admissible evidence or reason. You're not responsible for other people's actions, other than your children and those in your circle. But so the speculation is that why this random person started talking trash to you, it's not my business to be a mind reader. I can read mind, but I'm not here to babysit. There are some things that you, as a witness, if you cannot understand the answer or if you want to buy time to answer the question, just say, rephrase or rewrite your question. How is it so hard for you to answer this question? Rephrase your question, please, for I can have a better understanding of how to answer this question. There are some questions that asked in a certain manner that cannot be asked because it can be leading. So you have to ask rephrase. You can say objection, rephrase the question. Then there's the form objection, which is simpler to argument objective, which is form objectives is basically objection is trying to interpret the evidence that is basically you trying to put imagination to the evidence that's not even there. If say this attorney one witness, you came in and saw the clothes on the ground. Why did you not flee? Objection, Your Honor. Form objection. Inadmissible evidence and call for hearsay. That is due to the fact that Who knows why they're closing out? It's like similar to speculation, but in this scenario, it's not a mind reading. The person is looking at the facts of the situation at hand. The clothes was on the ground, but whatever reason why the clothes on the ground. I know, right? Role play. No figures. Don't forget, form, just and argument is both the same. One just badger the witness, push the witness buttons, intimidate, gonna jerk your nerve, blah blah blah. It's still a leading. Leading is not a leading is basically I'm leading you to an answer that I want you to hear from. It's not allowed in most court cases unless it's dealing with a hostile person or asking about a background or doing something where you can object that the leading can be done, like a direct examination. You cannot ask leading questions for cross examinations, only direct. So leading can ask you for a background. Where's your name? What's your date of birth? What place are you from? That's a leading question. So what is it? The next one is direct examination, which is similar to that. When you came in that day, why did you not leave? That's a leading kind of led you to why did you not leave? But it's hard to say. It's like 50 billion words, and it's different for state to state. That's direct examination. Cross examination is debating of what is right and what is wrong. Basically, that's the basic way to do it. Leading usually begin with, "Isn't it true? Isn't that what happened? You then do this. You then took the money and just left." Stuff like that. It is. Is it true that you did this? Stuff like that. While none my open-ended stuff or none leading questions like who or what happened or why it happened. How come this happened? Why didn't you do this? Why did you do that? Why did you do this? That could be confused with leading sometimes because they can go, why didn't you? Even though you knew. So isn't it true? Like bunch of bullcrap wordplay. Yay. That's objection part two, people.